Donald J. Trump petitioner versus United States. Justice Jackson dissenting. Justice Sotomayor has thoroughly addressed the court's flawed reasoning and conclusion as a matter of history, tradition, law, and logic. I agree with every word of her powerful dissent. I write separately to explain, as succinctly as I can, the theoretical nuts and bolts of what exactly the majority has done today to alter the paradigm of accountability for presidents of the United States. I also address what that paradigm shift means for our nation moving forward. 1. To fully appreciate the profound change the majority has wrought, one must first acknowledge what it means to have immunity from criminal prosecution. Put simply, immunity is exemption from the duties and liabilities imposed by law. In its purest form, the concept of immunity boils down to a maxim: the king can do no wrong, a notion that was firmly rejected at the birth of our republic. To say that someone is immune from criminal prosecution is to say that, like a king, he is not under the coercive power of the law, which will not suppose him capable of committing a folly, much less a crime. Thus, being immune is not like having a defense under the law. Rather, it means that the law does not apply to the immunized person in the first place. Conferring immunity, therefore, creates a privileged class free from liability for wrongs inflicted or injuries threatened. It is indisputable that immunity from liability for wrongdoing is the exception rather than the rule in the American criminal justice system. That is entirely unsurprising, for the very idea of immunity stands in tension with foundational principles of our system of government. It is a core tenet of our democracy that the people are the sovereign, and the rule of law is our first and final security. From their own experience and their deep reading in history, the founders knew that law alone saves a society from being rent in by internecine strife or ruled by mere brute power, however disguised. A corollary to that principle sets the terms for this case. No man in this country is so high that he is above the law. No officer of the law may set the law at defiance with impunity. All officers of the government, from the highest to the lowest, are creatures of the law and are bound to obey it. We have long lived with the collective understanding that decency, security, and liberty alike demand that government officials shall be subjected to the same rules of conduct that are commands to the citizen. For in a government of laws, existence of the government will be imperiled if it fails to observe the law scrupulously. 2A. These foundational presuppositions are reflected in a procedural paradigm of rules and accountability that operates in the realm of criminal law, what I would call an individual accountability model. The basic contours of that model are familiar because they manifest in every criminal case. Criminal law starts with an act of the legislature, which holds the power to define a crime and ordain its punishment. Criminal statutes are laws of general applicability that express the assent of the people's representatives that certain conduct is off limits in our society. When the federal government believes that someone has run afoul of a criminal statute and decides to exercise its prosecutorial discretion to pursue punishment for that violation, it persuades a grand jury that there is probable cause to indict. Then the government marshals evidence to prove beyond a reasonable doubt that the defendant engaged in the prohibited conduct and possessed the requisite state of mind. See United States v. Bailey. Observing that to hold a person criminally liable, the concurrence of an evil-meaning mind and an evil-doing hand must be proved. For his part, the defendant stands accused but is presumed innocent until conviction upon trial or guilty plea. Notably, criminal defendants have various constitutionally protected rights during the criminal liability process, including the rights to a speedy and public trial, the right to have a jury decide guilt or innocence, the right to the assistance of counsel, and the right to confront the witnesses against him. The defendant also has at his disposal many means to defend himself against the criminal charge. He can, of course, seek to hold the government to its burden of proof at trial, and even before trial. In a motion to dismiss the indictment, he might make any number of legal arguments. He can assert, for example, that the government's charging document does not give adequate notice of the charge against him, or that the law he has been accused of violating is unconstitutionally vague. He might further claim that the law is unconstitutional as applied to his particular conduct, and he might maintain that his conduct, even if proved, does not violate the law at issue. The defendant may also raise and attempt to prove affirmative defenses that excuse conduct that would otherwise be punishable. Generally speaking, affirmative defenses are determinations, often adopted by legislation, that certain conduct otherwise punishable by law is justified. This might be the case, for example, when the legislature determines that, under specific circumstances, the societal harm particular conduct causes is outweighed by the need to avoid an even greater harm. Importantly, a defense is not an immunity. Even though a defense can likewise result in a person charged with a crime avoiding liability for his criminal conduct. Consistent with our foundational norms, the individual accountability model adheres to the presumption that the law applies to all and that everyone must follow it, yet the model makes allowances for recognized defenses. One such defense is the special privilege that government officials sometimes invoke when carrying out their official duties. All of this is to say that our government has long functioned under an accountability paradigm in which no one is above the law. An accused person is innocent until proven guilty, and criminal defendants may raise defenses, both legal and factual, tailored to their particular circumstances, whether they be government officials or ordinary citizens. For over 2 centuries, our nation has survived with these principles intact. B. With that understanding of how our system of accountability for criminal acts ordinarily functions, it becomes much easier to see that the majority's ruling in this case breaks new and dangerous ground. Departing from the traditional model of individual accountability, the majority has concocted something entirely different, a presidential accountability model that creates immunity, an exemption from criminal law applicable only to the most powerful official in our government. 1. So how does this new presidential accountability model work? An initial problem is the lack of clarity regarding what this new model entails. The majority announces only its most basic contours, asserting that the nature of presidential power requires that a former president have some immunity from criminal prosecution for official acts during his tenure in office. Instead of no immunity, the individual accountability model, or an unqualified grant of absolute immunity for all official acts, the majority purports to adopt something of a hybrid. Footnote. Its feigned judicial humility notwithstanding, the majority's holding goes further, much further than necessary to resolve this case. Petitioner's argument in both the lower courts and this one was that a former president is categorically immune from federal criminal prosecution for all acts within the outer perimeter of his official duties. Thus, it would have been enough for the court simply to reject petitioner's categorical claim and leave it at that. But the majority sui sponte rephrased the question presented, and it now takes full advantage of this opportunity to devise from whole cloth an entirely new legal framework for judicial evaluation of potential criminal immunity for former presidents. End footnote. It holds that a former president may or may not be immune from criminal prosecution for conduct undertaken while in office, to be determined on a case-by-case basis. According to the majority, whether a former president is immune depends on how his criminal conduct is classified. as among three possible categories. First, with respect to any criminal conduct relating to a president's core constitutional powers, those subjects within his conclusive and preclusive constitutional authority, the president is entitled to absolute immunity from criminal prosecution. Second, expanding outward from this core regarding all other acts within the outer perimeter of the president's official responsibility, the president is entitled to at least a presumptive immunity from criminal prosecution. Third, if the criminal conduct at issue comprises unofficial acts, there is no immunity. Applying the majority's new presidential accountability model, it is important to note that the majority reframes the immunity question presented here as a separation of powers concern that is compelled by Article 2, as if what is being asked is whether Congress can criminalize executive prerogatives. But that is not anywhere close to what is happening in this case. No one maintains that Congress has passed a law that specifically criminalizes the president's use of any power that the Constitution vests exclusively in the executive, much less that the judiciary is being conscripted to adjudicate the propriety of such a statute. To the contrary, the indictment here invokes criminal statutes of general applicability that everyone is supposed to follow both on and off the job. So the real question is, can the president too be held accountable for committing crimes while he is undertaking his official duties? The nature of his authority under Article 2, whether conclusive or preclusive or shared with Congress or otherwise, is entirely beside the point. End footnote. Applying the majority's new presidential accountability model thus seems to involve bearing down on the indictment's allegations and making a series of determinations about the nature of the conduct at issue. From the structure of the paradigm, it appears that the first decision point is whether the alleged criminal conduct involves one of the president's core powers. If so, and apparently regardless of the degree to which the conduct implicates the core power, the president is absolutely immune from criminal liability for engaging in that criminal conduct. If not, then one must proceed to consider whether the conduct qualifies as an official act or an unofficial act of the president. If the crime is an official act, the president is presumptively immune from criminal prosecution and punishment. But even then, immunity still hinges on whether there is any legal or factual basis for concluding that the presumption of immunity has been rebutted. Alternatively, if the charged conduct is an official act, a determination that incidentally courts must make without considering the president's motivations, the president is not immune. The president is not immune. The majority's multi-layered, multifaceted threshold parses of the character of a president's criminal conduct differs from the individual accountability model in several crucial respects. First, for whether the relevant criminal statute reaches the president's official conduct ex ante, but again, what is at issue here are statutes of general applicability. They only reach the president's conduct to the extent that he chooses to engage in the prohibited behavior. Justice Barrett's framing thus sidesteps the fact that when immunity is being considered, what is actually at issue is whether the president is exempt from punishment if he opts to exercise his official duties using means that violate criminal law. End footnote. 2. The majority's multi-layered, multifaceted threshold parsing of the character of the president's criminal conduct differs from the individual accountability model in several crucial respects. For one, it makes it next to impossible to know ex ante when and under what circumstances a president shall be subject to accountability for his criminal acts. For every allegation, courts must run this gauntlet first, no matter how well documented or heinous the criminal act might be. Thus, even a hypothetical president who admits to having ordered the assassinations of his political rivals or critics, or one who indisputably instigates an unsuccessful coup, has a fair shot at getting immunity under the majority's new presidential accountability model. That is because whether a president's conduct will subject him to criminal liability turns on the court's evaluation of a variety of factors related to the character of that particular act, specifically those characteristics that imbue an act with the status of official or unofficial conduct minus motive. In the end, then, under the majority's new paradigm, whether the president will be exempt from legal liability for murder, assault, theft, fraud, or any other reprehensible and outlawed criminal act will turn on whether he committed that act in his official capacity, such that the answer to the immunity question will always and inevitably be it depends. Under the individual accountability paradigm, the accountability analysis is markedly less convoluted and leads to a more certain outcome. None of the same complications or consequences arise because, as I have explained, there are no exemptions from criminal law for any person, but every defendant can assert whatever legal arguments and defenses might be applicable under governing law. Since no one is above the law, everyone can focus on what the law demands and permits, and on what the defendant did or did not do. No one has to worry about characterizing any criminal conduct as official or unofficial in order to assess the applicability of an immunity at the outset. The majority's new presidential accountability model is also distinct insofar as it accepts as a basic starting premise that generally applicable criminal laws do not apply to everyone in our society. In the majority's view, while all other citizens of the United States must do their jobs and live their lives within the confines of criminal prohibitions, the president cannot be made to do so. He must sometimes be exempt from the law's dictates depending on the character of his conduct. Indeed, the majority holds that the president, unlike anyone else in our country, is comparatively free to engage in criminal acts in furtherance of his official duties. That point bears emphasizing. Immunity can issue for presidents under the majority's model even for unquestionably and intentionally egregious criminal behavior, regardless of the nature or the impact of the president's criminal conduct, so long as he is committing crimes pursuant to the powers invested exclusively in him by the Constitution or as needed to carry out his constitutional duties without undue caution, he is likely to be deemed immune from prosecution. Footnote: to fully appreciate the oddity of making the criminal immunity determination turn on the character of the president's responsibilities, consider what the majority says is one of the president's conclusive and preclusive prerogatives: the president's power to remove those who wield executive power on his behalf. While the president may have the authority to decide to remove the attorney general, for example, the question here is whether the president has the option to remove the attorney general by, say, poisoning him to death. Put another way, the issue here is not whether the president has exclusive removal power, but whether a generally applicable criminal law prohibiting murder can restrict how the president exercises that authority. End footnote. Ultimately, the majority's model simply sets the criminal law to one side when it comes to crimes allegedly committed by the president. Before accountability can be sought or rendered, the judiciary serves as a newfound special gatekeeper charged not merely with interpreting the law, but with policing whether it applies to the president at all. Also, under the new presidential accountability model, the starting presumption is that the criminal law does not apply to presidents no matter how obviously illegal, harmful, or unacceptable a president's official behavior might be. Regardless of all that, courts must now ensure that a former president is not held accountable for any criminal conduct he engages in while he is on duty, unless his conduct consists primarily and perhaps solely of unofficial acts. 3. The structure and function of the two accountability paradigms are not the only differences. The models also assign different roles to participants in the criminal justice system, and they ultimately generate different relationships between the presidency and the rule of law. Under the individual accountability model, duty-bound prosecutorial officers initially exercise their discretion to decide whether to seek punishment for alleged violations of criminal law, a determination that is made based on numerous factors. And even if prosecutors decide to bring a charge, a jury of the criminal defendant's peers ultimately determines whether that defendant, including a former president, will actually be held to account for having engaged in unlawful conduct. after the court has resolved any legal challenges and has instructed the jury as to the requirements of the law. By contrast, under the majority's new presidential accountability program, what a prosecutor or jury does may not even matter, since the courts take center stage once charges are brought against a former president, marshaling their resources to conduct a complex and amorphous threshold immunity evaluation, whether a former president will be entirely exempted from the dictates of the law, such that the roles of other participants in the criminal justice process become irrelevant, requires a judicial assessment in the first instance of his criminal conduct and the circumstances under which he acted. Finally, and most importantly, recall that under the individual accountability model, an indicted former president can raise an affirmative defense just like any other criminal defendant. This means that the president remains answerable to the law insofar as he must show that he was justified in committing a criminal act while in office under the given circumstances. In other words, while the president might indeed be privileged to commit a crime in the course of his official duties, any such privilege exists only when the people, acting either through their elected representatives or as members of a jury, determine that the former president's conduct was in fact justified, notwithstanding the general criminal prohibition. Under the majority's immunity regime, by contrast, the president can commit crimes in the course of his job even under circumstances in which no one thinks he has any excuse. The law simply does not apply to him. Unlike a defendant who invokes an affirmative defense and relies on a legal determination that there was a good reason for his otherwise unlawful conduct, a former president invoking immunity relies on the premise that he can do whatever he wants, however he wants, so long as he uses his official power in doing so. In the former paradigm, the president remains subject to law. In the latter, he is above it. 2. Justice Sotomayor has already warned of the dire consequences that are likely to follow from the majority's decisions in this case. I have thus far endeavored to merely explain what today's ruling amounts to on a theoretical level. The court's abandonment of the individual accountability model as applied to presidents and its introduction of a new presidential accountability model that authorizes the judiciary to exempt presidents from punishment under law depending on the official or unofficial character of the criminal conduct at issue. Here, I will highlight just 2 observations about the results that follow from this paradigm shift. First, by changing the accountability paradigm in this fashion, the court has unilaterally altered the balance of power between the 3 coordinate branches of our government as it relates to the rule of law, aggrandizing power in the judiciary and the executive to the detriment of Congress. Second, the majority's new presidential accountability model undermines the constraints of the law as a deterrent for future presidents who might otherwise abuse their power to the detriment of us all. A. Consider the structural implication of today's decision from the standpoint of the separation of powers. Until now, Congress's laws, passed by the representatives of the people, bound the people to their elected officials just the same. Law, we have explained, is the only supreme power in our system of government, and every man who by accepting office participates in its functions is only the more strongly bound to submit to that supremacy and to observe the limitation which it imposes upon the exercise of the authority which it gives. With its adoption of a paradigm that sometimes exempts the president from the dictates of the law, when the court says so, authority to bind the president, or not, to Congress's mandates, and it has also thereby substantially augmented the power of both the office of the presidency and itself. As to the former, it should go without saying that the office of the presidency, the apex of the executive branch, is made significantly more powerful when the constraints of the criminal law are lifted with respect to the exercise of a president's official duties. After today's ruling, the president must still take care that the laws be faithfully executed, yet when acting in his official capacity, he has no obligation to follow those same laws himself. But whatever additional power the majority's new presidential accountability model gives to the presidency, it gives doubly to the court itself, for the majority provides no meaningful guidance about how to apply this new paradigm or how to categorize a president's conduct. For instance, its opinion lists some examples of the core constitutional powers with respect to which the president is now entitled to absolute immunity, a list that apparently includes the removal power, the power to recognize foreign nations, and the power to pardon. However, the majority does not, and likely cannot, supply any useful or administrable definition of the scope of that core. For what it's worth, the Constitution's text is no help either. Article 2 does not contain a core powers clause. So the footnote. Some of the powers the majority designates as core powers are at best implied from indefinite constitutional language. Distinguish between official and unofficial acts. Quite the opposite. K and J concurring while acknowledging that this is a critical line that courts must draw in order for its new accountability model to work properly. Anything the majority simultaneously cautions that making this distinction can be difficult. The Constitution does not likely a gross understatement given the recognized breadth of the president's discretionary responsibilities under the Constitution and the laws of the United States. The majority likewise provides no guidance as to when, how, or why the president's presumptive immunity for non-core official acts might be rebutted, saying only that applying the criminal law to a president's acts must pose no dangers of intrusion on the authority and functions of the executive branch. At most, to distinguish official from unofficial conduct, the majority advises asking whether the former president's conduct was manifestly or palpably beyond his authority. But that test can be illusory, as is evidenced by the facts alleged in this very case. With respect to the indictment's allegations concerning petitioners' attempt to assemble false slates of electors in conjunction with the events of January 6, 2021, for example, the majority admits that the alleged conduct cannot be neatly categorized and that the analysis therefore may prove to be challenging. With that, at least, I could not agree more. This much is clear. Before today, none of these kinds of inquiries were necessary for criminal liability to be fairly assessed with respect to persons accused of having engaged in criminal conduct, and frankly, none is needed now, except as relates to the president under the new paradigm the majority has crafted. Perhaps even more troubling, while Congress, the branch of our government most accountable to the people, is the entity our Constitution tasks with deciding, as a general matter, what conduct is on or off limits, the court has now arrogated that power unto itself when that question pertains to the president. In essence, the court has now imposed its own preclearance requirement on the application of Congress's laws to a former president alleged to have committed crimes while in office. Who will be responsible for drawing the crucial line between the president's personal and official affairs? To ask the question is to know the answer. A majority of this court, applying an indeterminate test, will pick and choose which laws apply to which president by labeling his various allegedly criminal acts as core, or official, or manifestly or palpably beyond the president's authority. Ironically, then, while purportedly seeking to transcend politics, the court today displaces the independent judgments of the political branches about the circumstances under which the criminal law should apply. Effectively, the court elbows out of the way both Congress and prosecutorial authorities within the executive branch, making itself the indispensable player in all future attempts to hold former presidents accountable to generally applicable criminal laws. The framers, however, did not make the judiciary the overseer of our government. To be sure, this court may sometimes have to intervene in determining where authority lies as between the democratic forces and our scheme of government, but it has long been understood that we should be wary and humble when doing so. The majority displays no such caution or humility now. Instead, the court today transfers from the political branches to itself the power to decide when the president can be held accountable. What is left in its wake is a greatly weakened Congress, which must stand idly by as the president disregards its criminal prohibitions and uses the power of his office to push the envelope while choosing to follow or not existing laws as he sees fit. We also now have a greatly empowered court, which can opt to allow Congress's policy judgment criminalizing conduct to stand or not with respect to a former president as a matter of its own prerogative. B. If the structural consequences of today's paradigm shift mark a step in the wrong direction, then the practical consequences are a 5-alarm fire that threatens to consume democratic self-governance and the normal operations of our government. The majority shoos away this possibility, accusing the dissent of striking a tone of chilling doom that is wholly disproportionate to what the court actually does today. But Justice Sotomayor makes this point plain, and I will not belabor it. Here, I will merely observe that, from a theoretical perspective, philosophers have long considered deterrence to be a key justification for adopting and maintaining systems that ensure accountability for criminal conduct. Footnote: see Plato, Laws. Not that he is punished because he did wrong, for that which is done can never be undone, but in order that in future times he, and those who see him corrected, may utterly hate injustice, or at any rate abate much of their evil doing. See also J. Bentham, The Rationale of Punishment. General prevention ought to be the chief end of punishment, as it is its real justification. A. von Hirsch, Doing Justice, The Choice of Punishments. The threat and imposition of a punishment is called for in order to secure compliance. Not full compliance, but more compliance than there might be were there no legal penalties at all. C. M. Ryan, Taking Another Look at Second Look Sentencing. Undermining the certainty of punishment could undermine the deterrence value of punishment. End footnote. For that same reason, some commentators also maintain that the decreasing the certainty of accountability for wrongful acts at least arguably reduces incentives to follow the law. Under the individual accountability model, because everyone is subject to the law, the potential criminal liability operates as a constraint on the actions and decisions of everyone, including the president. After today, that reality is no more. Consequently, our nation has lost a substantial check on presidents who would use their official powers to commit crimes with impunity while in office. So, one might ask, what remains of the accountability for presidents under law? With today's paradigm shift, the majority leaves in place only the chance that this court might someday determine that the criminal conduct in question was an official act, or that the government will somehow rebut the presumption of immunity that applies to a president's official acts such that criminal consequences might attach. But with the parameters of official and unofficial conduct unknown, I think it highly unlikely that a sitting president will feel constrained by these remote possibilities. All of this leads me to ponder why exactly has the majority concluded that an indeterminate core versus official versus unofficial line drawing exercise is the better way to address potential criminal acts of a president. Could it be that the majority believes the obviously grave dangers of shifting from the individual accountability model to the presidential accountability model might nevertheless be offset by the great benefits of doing so? Some of the majority's analysis suggests as much. As far as I can tell, the majority is mostly concerned that, without immunity, presidents might be chilled from taking the bold and unhesitating action required of an independent executive. The court's opinion candidly laments that application of the law to presidents might not be even-handed, and that as a result, presidents might be less vigorous and energetic as executive officers. But that concern ignores or rejects the foundational principles upon which the traditional individual accountability paradigm is based. Worse still, promoting more vigor from presidents in exercising their official duties and presumably less deliberation invites breathtaking risks in terms of the harm to the American people that, in my view, far outweigh the benefits. This is not to say that the majority is wrong when it perceives that it can be cumbersome for a president to have to follow the law while carrying out his duty to enforce it. It is certainly true that a scheme of government like ours no doubt at times feels the lack of power to act with complete, all embracing, swiftly moving authority. But any American who has studied history knows that our government was designed to have such restrictions. Our Constitution's separation of powers was adopted by the Convention of 1787, not to promote efficiency, but to preclude the exercise of arbitrary power. The purpose was not to avoid friction, but to save the people from autocracy. Having now cast the shadow of doubt over when, if ever, a former president will be subject to criminal liability for any criminal conduct he engages in while on duty, the majority incentivizes all future presidents to cross the line of criminality while in office, knowing that unless they act manifestly or palpably beyond their authority, they will be presumed above prosecution and punishment alike. But the majority also tells us to not worry, because, like everyone else, the president is subject to prosecution in his unofficial capacity. This attempted reassurance is cold comfort, even setting aside the fact that the court has neglected to lay out a standard that will reliably distinguish between a president's official and unofficial conduct. Why? Because there is still manifest inequity. Presidents alone are now free to commit crimes when they are on the job, while all other Americans must follow the law in all aspects of their lives, whether personal or professional. The official versus unofficial act distinction also seems both arbitrary and irrational, for it suggests that the unofficial criminal acts of a president are the only ones worthy of prosecution. Quite to the contrary. It is when the president commits crimes using his unparalleled official powers that the risks of abuse and autocracy will be most dire. So the fact that, unlike anyone else, the president is vested with sweeping powers and duties actually underscores rather than undermines the grim stakes of setting the criminal law to the side when the president flexes those very powers. This vision John Adams enshrined in the Massachusetts Declaration of Rights, a government of laws and not of men, speaks directly to this concept. Adams characterized that document as an homage to the rule of law. It reflected both a flat rejection in positive terms of rule by fiat and a solemn promise that every act of government may be challenged by an appeal to law. Thanks to the majority, that vision and promise are likely to be fleeting in the future. From this day forward, presidents of tomorrow will be free to exercise the commander-in-chief powers, the foreign affairs powers, and all the vast law enforcement powers enshrined in Article 2 however they please, including in ways that Congress has deemed criminal and that have potentially grave consequences for the rights and liberties of Americans. 4. To the extent that the majority's new accountability paradigm allows presidents to evade punishment for their criminal acts while in office, the seeds of absolute power for presidents have been planted. And without a doubt, absolute power corrupts absolutely. If one man can be allowed to determine for himself what is law, every man can. That means first chaos, then tyranny. Likewise, if the government becomes a lawbreaker, it breeds contempt for law. It invites every man to become a law unto himself. It invites anarchy. I worry that after today's ruling, our nation will reap what this court has sown. Stated simply, the court has now declared for the first time in history that the most powerful official in the United States can, under circumstances yet to be fully determined, become a law unto himself. As we enter this uncharted territory, the people, in their wisdom, will need to remain ever attentive, consistently fulfilling their established role in our constitutional democracy, and thus collectively serving as the ultimate safeguard against any chaos spawned by this court's decision. For, like our democracy, our Constitution is the creature of their will and lives only by their will. For my part, I simply cannot abide by the majority's senseless discarding of a model of accountability for criminal acts that treats every citizen of this country as being equally subject to the law as the rule of law requires. That core principle has long prevented our nation from devolving into despotism. Yet the court now opts to let down the guardrails of the law for one extremely powerful category of citizen, any future president who has the will to flout Congress's established boundaries. In short, America has traditionally relied on the law to keep its presidents in line. Starting today, however, Americans must rely on the courts to determine when, if at all, the criminal laws that their representatives have enacted to promote individual and collective security will operate as speed bumps to presidential action or reaction. Once self regulating, the rule of law now becomes the rule of judges, with courts pronouncing which crimes committed by a president have to be let go and which can be redressed as impermissible. So ultimately, this court itself will decide whether the law will be any barrier to whatever course of criminality emanates from the Oval Office in the future. The potential for great harm to the American institutions and Americans themselves is obvious. The majority of my colleagues seems to have put their trust in our court's ability to prevent presidents from becoming kings through case-by-case application of the indeterminate standards of their new presidential accountability paradigm. I fear that they are wrong. But for all our sakes, I hope that they are right. In the meantime, because the risks and power the court has now assumed are intolerable, unwarranted, and plainly antithetical to bedrock constitutional norms, I dissent.